the meeting to order.
I move we approve the agenda.
Second.
Pledge of, yes, sir.
I'm just
Oh,
voting.
just, okay, oh yeah, voting for,
Yeah.
just
So,
approve.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And I don't believe we have any public comments unless,
Oh, we have
you know.
fishing.
I believe everybody has seen, hopefully, the minutes, the draft minutes.
So moved.
Second.
So moving right into discussion of findings regarding prospective firms. Mr. Strubinger, would you like to start?
Yeah, I had two that I checked on.
Okay,
Both of them are good.
good.
Davidson et al. Davidson Rand Flyer, I think it is. It's not player, it's
Flyer, yeah.
Flyer. I talked to Michael Wren, who's the second name. Checked with his, he has no conflicts, not aware of any conflicts. The general, they covered all these areas, advocacy, litigation, constitutional law, government, insurance, law enforcement, medical malpractice. They also cover employment, which is one of the things I asked him about, is most of our cases. But the star for Michael Wren is that he has extensive experience in FOIA and school boards.
Oh, good.
So I thought that was a big star
Great.
for him. And I also called Hainsworth et al. And spoke to Parker Barnes. And they are a huge company, huge. So they do everything. Mostly finance, bonding, and real estate. And Parker also does employment. The star for him is that he is from Beaufort, his family's in Beaufort, and he knows the Beaufort judges. And that's a pretty big star.
Yeah. Big star.
So I think they're both winners. For
Yeah,
different
I'm sorry,
reasons. I think Wren is a winner for the FOIA expertise. And Barnes for any local employment issues.
Did you find out, they obviously didn't say they had any conflicts.
No, David says no conflict. Parker Barnes ran it. They have software that checks conflicts. And he ran it and it was negative.
Okay, and I know rate information, we're just gonna submit and put that in
Yeah.
to executive.
They were,
session.
Wren was 200 to 450 depending on whether you're an associate or
Yeah.
partner. And, Hainsworth was 175 to 450, so that's comparable. So they're both good. They're both good. I don't know how to format. These are just my notes, so I don't know how we want to format it, but I can.
Well, what I had anticipated doing is taking the notes, compiling them, and I'm not going to be at the March 5th
Right.
meeting, but I'd like to give them to you all for, of course, approval, and then moving forward with that. I was going to draft it all today.
David,
Well, I
Yeah,
can do it all
David,
this.
excuse me,
Yeah.
I don't have the list in front of me. What were the two names again?
It's the.
Davidson, Wren, Flyer, PA is the first one I have an asterisk next to.
Okay, thanks.
And I spoke to Michael Wren. And the second one was Hainsworth et al.
Okay.
And it's actually not player, it's listed as player, but it's
Yeah,
flyer.
Flyer.
Is that Gary playing at the golf?
We don't want players. Yeah, fly lure.
Fly lure?
You want my notes?
Yes, please.
You can disregard that top line.
Okay.
Thank you.
That
You
was-
know, you need.
Yeah, I was looking for.
Grocery list?
Looking for a line.
Okay. And, yeah.
Okay, I talked to Rosen, and Haygood, and they are a Charleston firm. They have been the firm that has had the contract for legal services for the Charleston School District.
School district?
Yes. Their practice areas are administrative and government, business and commercial litigation, business and corporate law, construction law and litigation, education and school law, employment and labor, family law and divorce, insurance, bad faith, personal injury, and of course probate. I found that their rates are higher. Their rates are $375, and that's what they charge the Charleston School District.
Is that for associate or partner or?
I talked to a partner.
Okay. So it's a partner's rate.
Yeah, it's a
Okay.
partner's rate, okay. And they've got a lot of experience in going along with what David said, in the Charleston courts. And that's, if you don't know, that's where federal court is. And if we ever had to appear or had something be brought up in federal court, they would probably, or the other firm, one of the big firms in Charleston should be the ones that we hire. Yeah.
That's also where the U.S. Attorney's Office is.
Yes, that's correct. And these people are litigators as well as school law. So, would really like to work for us, of course. But I was very impressed. Got some information on them and their areas of practice. And then I talked to Stacy Canaday of Tupper, Grimsley, Dean, and Canaday. And they got an email from them that I'll give to you. They represented the district from 1983 to 2007. 2007 is the last time they were looking at the district. Contractual matters, real property transactions, litigation to include construction-related matters, litigation and general advisory matters. Typically, a lawyer from our firm attended each board meeting. That's when they were the overall omnibus firm that the district had. And then before they hired in-house counsel. They have 4 attorneys, multiple support staff, multiple experience in various practice areas. We are unable to assist in bond-related matters and criminal matters and bankruptcy. Her partner, Erin Dean and her are the primary litigators in personal injuries and construction defect litigation, both in Beaufort and other areas. Erin also serves outside counsel for the Beaufort Jasper Water Authority. So that might be a conflict if we ever had an issue with that. Grimsley hands real estate. Tupper is general litigation and mediation. And he does a lot of mediation work in the Beaufort area. Their fees, $275 an hour for attorneys, $100 for paralegal plus cost expenses and fees, and they bill on a monthly basis. They have a good local reputation. And, for local litigation, I would think they would be the ones we'd want to work with because again, but if this other firm has a lawyer that's from here, that works the same way. It's nice to have a couple. So, you
Someone might be
always good to have.
always good to have.
I go with Grimsley, I always say, eliminate Grimsley. You'll take anybody from the front, but.
Yeah, that's.
Yeah, that's the one that I had
Because that's a
stricken
little
through.
cloud.
Yeah.
I had stricken through Grimsley
Yeah,
on
right.
there.
Right.
Cause they were the one that was the local firm that had.
Right. That's my 2.
Okay.
Now, do you want these notes from Emerson? Remember the Emerson?
Yeah, thank you. That's because actually I didn't print them out, but so since there's been people that have talked, I didn't get a chance to speak with Mr. Emerson, but I know that we have his rates and fees, and that's already been vetted, but I did speak,
I forgot an email from you.
right. I spoke with, Vox Marsher Berglund. They, depending on the matter, they didn't want to give the fee, which is sometimes common, but, they do have a good local reputation. Where are my notes? Here. She gave me their areas of expertise, which are, Mr. Berglund's areas are personal injury and workers' compensation. Mr. Vox, that's Tabor Vox, personal injury. Mr. Marsher is real estate predominantly, and they also have another associate, named Meyer, M-E-Y-E-R, and he's predominantly criminal and family. So those are their areas. Rates I don't have, and conflict you would have to speak with the.
Pretty limited, I mean.
Yeah, limited area, but, I did like that they had someone that did workers' comp that would be local, and then, personal injury, also just in case, and, real estate.
Yeah, they really,
Also.
their reputation is real estate. They are
Mhm.
Sun City, all the new developments, up and down the bluff. They pretty much were the lawyers that handled all the transactions.
Yeah, they've been around for
Yeah.
as long as
We
I've
have
had.
I try to think, what comes to the board, what issues come to the board.
Yeah.
Right.
Employment, student rights.
Right.
Possibly real estate.
Right.
Mhm.
And FOIA, those are like the four things I thought of.
Although we do have some, we do need to look at our properties that we have that are not producing anything for us.
There are properties we can't even build on.
Oh, exactly. And
They're
that-
prohibited.
Right. And so we might need some real estate assistance, dealing with that.
I did wanna make note just for the record that the district liaison, we don't have one here today. Just wanted to know that. I emailed Dr. Berg and told him that Wendy wasn't gonna be able to make it, he said he was going to try to. He told me he was welcome to send somebody else too. But with all of those firms gone through, did anybody else have any other questions?
So our product is to give to the full board a menu of
Okay.
firms.
Yes, and then just to be
And say-
prepared to answer questions
Answer
if they
questions
ask.
if anybody has any objections to it, and then vote to accept that, and then we just keep it on file, and then we call as needed.
It's our general list, and it's good for us to have all their areas of expertise,
Right.
so whatever matter comes towards us, if we need them, we can put on the list if that's the area and that's the firm, and it's appropriate for federal, it's appropriate for
Right.
local, we have a good narrowed down list.
And do we need to say something about who can do this? I mean, do we need to have, we shouldn't have to have a vote if we have a.
We've already given the chair
Right,
the.
right,
the
but there's
authority
been
to
some
do it.
back and forth about that.
Well,
We've already had a motion
The
that
back
passed
and
that.
forth was that the second part of that motion was that we had to have this list. That was the back and forth.
Okay.
But now,
Emerson's email.
Thank you.
that motion, I thought that motion was for a one time. I didn't know that motion was for every time we get an emergency event.
We can look back to it, and if it's not in policy either, also, it can be something that we can put forth to maybe the policy subcommittee to consider, because that should be a policy of who makes those decisions.
Right.
If it's not one already.
Right.
It's not a policy, but you have a motion that was passed in July that has not been, has not been rescinded or
I see.
changed.
I see.
And so
With
it
the
was,
board.
correct, and the majority have passed. The only thing, as what David said, was you didn't have that piece of the list.
Got it.
But that motion passed unanimously of July of 2018.
And that's to get the chair and authority to pick from the list.
Correct.
And now we have the list.
And now you have the list.
Now we have a list.
As long as it's
As long as
up for-
Right.
everybody.
But we should memorialize it in policy.
Right, I agree.
Motion passed such and such.
So,
So,
correct me if I'm wrong, until this list gets approved by the board, we have to go back to the April measure, which was the board, actually August of 18, but the board has to vote for each hire. every time. And then as soon as this list is approved, the chair has the authority to go down this list, but she has to stay on the list.
Yeah, I'd have to review the motion or whatever it was and how it was
Well-
worded, but, cause I don't know offhand since I didn't serve then, so.
Yeah, I'll have it with me Monday
Yeah,
night.
yeah,
okay?
that'll be good.
Because it was clear that, the list had to be approved by the board. So until that happens, the previously expressed will of the board is
Was-
still in force.
Yeah,
It's an interesting perspective, which we can't rule on. It's an interesting perspective.
that was the,
Yeah.
okay, so, does anyone want to make a motion to approve this?
So moved.
And do you
I'll
wanna,
second.
would you like to go down it just for confirmation?
No, second.
Okay.
But before we adjourn, I wanna recap what we're gonna report to the board,
Okay,
so that we all agree on what we're gonna report. We went through the list.
yes, sir.
We eliminated, companies that had previously worked for us. And you're gonna have to explain why we didn't eliminate Grimsley on that one. But, so, I'm anticipating
Right.
some of the questions.
Right.
We went through, we eliminated anybody so that we had all clean slate, all got the areas of expertise, and that's basically our report.
I have a question for correction of the minutes.
No, it's good.
So you ended up
That's
removing
correct.
all firms having, or just the
Site to include the
attorneys
firms.
within the
Not
firm?
the attorneys.
Did we still keep the firms but not using the attorneys?
That's a good question.
Because
I think that's the only one, it only
was
applies to
Grimsley.
one firm, I believe.
Only one.
We eliminated the firms except for
Except for a
the
couple.
local firm.
And,
Right.
and
There we
Mr.
just
and Mr.
eliminated
And Mr.
the firms.
Grimsley would not. And, I didn't mention that to, Ms. Kennedy, but, that could be done easily, on the side, saying, if we come to you, we're gonna ask that Mr. Grimsley not be, involved.
Yeah, I mean, he would have to report any conflicts under some kind of our ethics rules,
Right.
that he may have, and we can strictly hire and say that, but that's the whole purpose of also having other options with local firms.
So, the
Grimsley's
line I
part of
used,
it.
because we had the conversation, the committee decided when we met the last time, you decided we weren't going to keep the firms, we just weren't going to use the attorneys. Because I guess that included Grimsley. So, do you
Yeah, I
not
think-
want to say, since you're keeping Grimsley's firm, not to say you eliminated all the firms, so there's not a one and done, you just chose the firms that you chose because of what they did, but not to say you eliminated all the firms dealing with.
Well,
So you don't have to do the exception of, well, why did we keep
Right.
Grimsley
Right.
and not so and so and so and so?
right.
We just have to be accurate about what we actually did.
Correct, right, I think it
Correct.
was kind of inferred possibly, maybe it wasn't exactly expressly stated when we were going through that list, but I have, my list here from last meeting, and we went through every single attorney on all these firms and crossed out ones, went over it with Wendy
Mhm.
and with Robin about who may have a potential conflict, and then when we tried to narrow it down to the information we had handy, we looked at the firms, obviously, that had major conflicts, crossed them out, or not major conflicts, excuse me, but a lot of attorneys possibly serving, and then we went to the ones that were good candidates, we thought, and we vetted them again. We did discuss 2 local firms, to follow up with, and that was the Tupper, Grimsley, Dean, Kennedy, and Fox, Marshall, Berglund. And like you said, the Tupper, Grimsley, Dean, Kennedy hasn't, their last end date was in 2007. So, a decade, I think, is a good spread, but, I guess that's up for everyone to decide. If we wanna take
There was a cloud over
them,
this.
if we wanna take them out, that would leave us only with one local firm.
And that's a relatively recent cloud, and,
I don't know how it developed, I just saw it pop up and it's like, okay,
yeah.
I don't wanna hand anybody something on a platter to
Right.
back.
Yep.
Just so I don't have to bog down the conversation Tuesday. Does that square what we talked about when we casually mentioned it, that, because last meeting, we were talking about the fact that even if you discount certain lawyers within a firm, if a junior lawyer takes it, they're gonna go to they're gonna be supervised by the senior partner that may well have been doing business with us. And so that's what my understanding was, is that the whole firm
Was going out the door.
was going up.
Gotcha. Okay. Well, we're certainly welcome to consider that in our list that we put forth, or we can include them and explain it at the meeting. It's totally, open.
Cause did you discount Halligan, Mahoney and Williams? Cause I had people, you didn't take the firm off, but you took people out.
I crossed them out, but they weren't one that we vetted
Right.
second.
Exactly.
Because they had already been vetted for, that other matter.
Right.
And we were trying to come up with a general list, a bigger list.
Well, if you,
So it's
my
Halligan.
only point about Tupper,
No.
Grimsley and Dean
Okay.
is that's only the second firm in the local Beaufort area. And if we just eliminate Grimsley, if we only eliminate Grimsley,
Good
then we'll only have just one.
Right.
And that could be a problem of
Good explanation.
accessibility.
That's a good explanation.
So, and what the problem with, Grimsley was not something that we're probably gonna be involved in, cause it was a real estate, issue that is well beyond our scope that we'd ever use.
Well, how about this as let me float this idea then, if it was a real estate issue. Why don't we, specifically with regard to the local firms, put a caveat on there that, Tupper, Grimsley, Dean, Canada, will deal with matters non-real estate related. And Box, Marsh, or Berglund, since they are a huge real estate firm, we designate them as ones that would deal with our real estate matters locally.
It's logical.
Seems like it.
And even though, John, to your point, even though, he is a partner, he's basically semi-retired, and he's basically
Oh,
semi-retired.
that one I understand.
and
I'm
not-
talking about another.
Oh, I understand,
another firm.
but I just.
Yeah, semi-retired is not gonna be called upon on a daily basis to help the junior associate solve whatever problems that he or she is working with. So, yeah, that's not an issue.
Okay, so for the record, and to confirm, I'm gonna write this down and then we're gonna formalize it for someone from the committee to present to the board and answer questions accordingly. I have non-local, Davidson, Wren, and it's Plyler, Plyler. We also have Hainsworth, Sinkler, and Boyd. Rosen, and Haggard?
Hey, good.
Hey, good, thank you.
Ran out of Rosens, I guess.
Pardon?
They ran out of Rosens.
I wrote Rosen times two. And
Oh,
then
sorry.
for local, wait, sorry, did I skip one?
Emerson, are you gonna do Emerson?
Oh, Emerson, yep, sorry.
Emerson Law.
Emerson.
Right here.
Law.
Emerson. And then for local, we're going to put down Tupper, Grimsley, Dean, Canada for non-real estate. And Box, Marcia, Berglund for all matters including real estate. And all matters that they handle. Plus real estate. Sorry, I would do it shorthandedly with Tupper, Grimsley, Dean, Canada, Box, Marcia, Berglund.
Okay.
And they do have an associate.
Ah,
Mrs.
yes,
Meyer.
Fox, yeah.
Okay.
I just made the connection between Fox and Sun City. Yeah.
And also, I think that for certain things that, we have the school board association attorneys that we can use from time to time that we should have used before we start spending money to use some of these outside sources for quick questions.
Oh, yeah.
Oh, yeah,
Yeah.
they
Oh,
have
yeah.
that free legal
Yeah.
service.
Yeah.
Yeah.
You can call.
Consulting.
Right, so we need to make
This
sure
is for
that.
actually retaining a
Right.
firm, if we actually have a matter that we
This is
get to the point where we have to hire somebody.
Represent us in court.
Right, but I mean, but I just, even when y'all say that, even when y'all giving these firms, it maybe we need to make a suggestion that even before we retain the attorney, if this matter is a serious matter, then we need to see what we can use the school board, because now I don't want the chair or the board says, well, we have, let's go through this. Every time we're just going through this and we're not thinking about other free legal services that we have. That's just.
If I heard you right, once this list is approved, we're out of the selection business. Nobody on the board, the chair is empowered on her own to retain any of the councils on this list without consulting the board.
Right, and so that's why.
But, it is not correct, but the board gives permission for the chair, this is what the issue is. Okay?
Yeah,
Now-
by specialization.
Right, yeah.
I mean, it's all gonna depend on the matter, because if we get sued first, we need to go retain somebody. We can't exactly be going and talking to someone for free, because that's not gonna help us any. You need to go to your list, find who's in that area of specialty, and give them a retainer to defend you quickly.
If I could give an example, we got this letter from Principal Tansmore, and we have yet to respond to that. In that particular case, we could say in executive session, we need to respond. And that's all we need to say, and then the chair can go in and
Right, that's something
Get somebody.
Right, that's different. But if we happen to battle or something, and they say, well, we need to find something out, I don't want the chair going and say, well, you know what, I just go through this. Because sometimes some people go after, some people say, well, it's debatable, and then we decide to want all your opinions on everything. That's, you know what I'm saying? Now we're spending taxpayers' dollars on getting legal opinions.
Right.
Versus when we can get them for free.
well, we have our own in-house lawyer too.
Right, but she doesn't like to get involved in that stuff.
No, but she can also give us advice without having to pay or anything.
And I agree, but also in the past, when I gave her things, she kind of liked to not much get involved in it.
No, we made it quite clear that the district has their attorney and the board has its attorney.
Yeah.
We made it quite clear, so I think she's smart not to cross that line.
Right.
Board's attorneys for the board, and not the private attorney for any of us.
Well, I'll leave that alone, I mean, I'll have that with that.
You can call the association
She's smart not to
as
step over
individuals
that.
if we have a question. Talk to their lawyers. It's part of our $50,000.
And just for the future reference, I'm not comfortable, and I just said to me, not surprised it doesn't mean, I'm not comfortable with every time we have an issue that, the chair just jumps up and we say, hey, that's a one-person decision, and make the decision. I understand if something arises, then, that happens, but if something is coming up and that we know, then, I think, sometimes two heads are better than one. Because someone may have other knowledge of something in the past, or you have some of us that may actually go to court, see how one attorney might have performed or how they've done in this case, and that could be questionable. So that's just my opinion from actual understanding litigation, understanding the court, really understanding everything. If the chair hadn't been in court, then that's a different view. So that's just my point.
Write that up as a motion, and on Tuesday, you make as a motion underneath of our report. That, even this report would open that up to a motion that you want to make.
Yeah, would it be considered an amendment to the July?
No, but it opens up the topic.
Opens up the
So that
topic,
you don't have to worry about it not being on the agenda.
Yeah.
This will be on the agenda, so you can make a motion like that to modify. Because currently,
Currently it's in the book.
the chair can I didn't pick anybody on that.
Right.
So,
So you gotta-
try to, work it into a motion and then.
The only thing that can change that is board action.
So this, again, your concern is that the board chair will, on her own, hire an attorney without checking with anybody, without consulting anybody else on the board, or mentioning it in executive session. Is that the concern?
Yeah, pretty much, yeah, somebody, yeah.
Okay.
Because she wasn't single-handedly running the district by herself.
I understand.
Right.
But I'm trying to think of when that might happen. What would cause that to happen? You just wanna prevent that.
I will prevent that from happening before, I mean, because once you play defense, once it happens and you say, oh, we should have did this, we should have, but we didn't do it. So now while we have time before an emergency or some situation like that does occur, then it's already done.
So-
I mean, because if even if an emergency does happen, then we need to, we can call a meeting and we can discuss it. I mean, that's our job.
Or would it be acceptable to say that there be language in the motion that in consultation with the other officers?
What you think about that? What you think about that? You be sure about it.
I think you gotta look at it and balance it against what stands right now as the will of the board. And the will of the board was a motion passed in either April or June, I forget which, that says, once this list is approved, the chair has the authority to go off and hire. Now, that doesn't say that the chair has to consult with the board, the chair can go off and hire. Now, as to how that could happen, I can't tell you, but I can tell you from history how it has happened, okay? Is that attorneys have been brought in to work board issues without the board having any knowledge of it. Okay? So, that measure that developed the need to have this list was a result of the dissatisfaction with that. So the idea was to have a list that everybody was comfortable with the attorneys, because people had issues with some of the attorneys that were being used. So this list is supposedly an endorsement of all these lawyers, so it doesn't matter if we're consulted, really, okay? So to change that, you gotta make a motion. I'd prefer that you try to change it in policy, to tell you the truth, because will of the board motions tend to get forgotten over time, unless somebody's a good archivist. So you could come to the policy committee and with your suggestions, and then we could perhaps gin something up. And that's within the scope of our committee. But I don't think having this list approved and then trying to get it so that the board has to be consulted every time one of the persons on that list is selected, I don't think that will fly. And I don't think it's necessary either. If we all have confidence in these attorneys.
Mr. Scrivener?
I would suggest that you might want to make your motion. If time allows, the board will be consulted.
There you go. I'm good with it. I'm good with it.
Because that
Yeah.
seems to be the
Right.
Time allows,
If time allows,
the board
yeah.
will be consulted.
And I'm
That's
good
a
with
good
that.
idea.
Thank you, David. That's my point right there.
Can,
And the advantage of a
as-
motion is it takes effect immediately.
For
So,
clarity,
as it passes.
just looking back at the, I guess this is from the June 19th meeting of the COW committee, okay? The motion, yeah, I call.
It's hard not to smile, I
Yes.
know.
So Ms. Mary Cordray made the motion
Yep.
that the board authorize the officers to engage outside legal counsel to facilitate the business of the board as needed. A list of acceptable options will be developed by the board, but now it's been given to us. The motion passed 7-3-1. So it does currently read
That
in
implies
the
the officers.
officers,
So it's
not just the chair.
Not just the chair.
So, but then if you would like it to be brought forth to the policy subcommittee for consideration to memorialize it, you know.
Yeah, I would make the motion and then put it in policy.
Yeah, whatever.
That's faster, because you don't go through 3 readings.
Don't forget though, if the officers are gonna get together and talk about it, they have to post a meeting. That's not a confidential, that's not fodder for executive session.
Yeah, I've gotten that, yeah.
Information.
I've gotten that from you already, yeah, I understand. Yeah. I have a problem with transparency.
I'm sorry?
Nah, it was me, I said, you're right, you're absolutely correct, I said, I don't have a problem with transparency at all.
So,
Can I make a suggestion?
sir.
So, I would suggest that you just take a vote on what you just wrote down, so that you can tell the board, full board, that the committee passed it.
That's what I was about to do.
Huh?
That's what I was about to do.
Oh, okay.
Do I have a motion to approve the list? Davison, Ren, Flyler, Hainsworth, Rosen, times 2, Haygood, Emerson, Tupper for non-real estate engagements, and Fox Marshall Berglund for all other types of engagements locally and including real estate.
So moved.
Second.
All in favor? Unanimous. Awesome sauce.
You're going to send that to me and I can put it in the board docs for the.
Yes, and yeah, I guess there's no need to really include these notes, but if you guys would like,
No, I just thought we would put, like the ones I talked to, they had a star, like the guy who knows
Right.
the local judges. That's important information. The guy who has experience with FOIA and school boards, that's important information.
yeah. Okay, so I can add those notations onto this list to give to Robin.
Yeah, I think that would be helpful
Okay.
to whoever's making the decision.
So,
Good job.
Now, once this is done and this is passed, then the ad hoc committee goes away, correct?
Well, if you wanna play it by Robert's
So-
rules, an ad hoc committee, when it delivers a report to the board, is dissolved. There's 2 ways you can do it. You can ask that it become a standing committee, or you can say that you expect to be reformed if any things come up.
On an ad hoc basis.
Huh?
On an ad hoc basis.
Yeah. So you don't have to be dissolved when you get the report. That would be the normal process, but you can do anything you want, really.
So then I don't think that we need to set any future meetings. And,
Are you adjourning?
I'm adjourning.
Good job. Are you gonna be there Monday night?